I am Talibita Moses, and today I want to talk about the introduction to business law. Well, I will start with the definition of law. Law, the definition of law can be found in the Black's Law Dictionary or in the Concise Law Dictionary, but law may be defined as a body of rules and regulations governing or regulating society, the enforcement of which is effected by way of sanctions. Now, there are different classifications of law. There is criminal law vis-a-vis civil law, there is public law versus private law, there is the substantive law, which talks about your rights, and there is the procedural law, which talks about the processes unto which you can have your right that has been violated reinstated. And then there is also broadly what we call the local, or call it municipal law, and the international law. Now, criminal law, this branch is characterized by certain conduct, acts, or omissions, or wrongdoing as offenses against the state or the public. So, criminal law emanates from the term crime that signifies an act of disobedience to the law, and such disobedience is normally punishable by sanctions ranging from death, imprisonment, fine, or even a caution, and the others. Criminal law is normally enforced by police, the Directorate of Public Prosecutions. However, in some cases, a private person can also initiate or commence criminal proceedings. This is called private prosecution in the event any public conscious person sees anybody breaking the law and they think they can prefer charges on them. Where private prosecution has been commenced, the Director of Public Prosecutions under the Constitution has powers to certainly take over because he's the one who prosecutes, he has the resources, and he does that in the public interest. It is important to note that cases involving abuse of office, corruption by public officers are prosecuted by the Inspectorate of Government. Under criminal law, a person is innocent until he's proven guilty, and until he pleads guilty, and the burden of proof lies on the prosecution, which of course is emphasized by the reasons why somebody should not be held incommunicado or in police cells before he's being charged for a period of not more than 48 hours. The Constitution says so. Now, under civil law, certain or rather concerns itself with the rights and duties of persons, that is, human beings or artificial persons, those are companies or organizations or legal entities or government, towards each other. For instance, the law of contract, which concerns obligations or consequences of parties to agreements, the law of torts, which concerns civil wrongs for which a remedy lies in the damages, for example, motor car accidents, accidents at workplaces. There is a duty of care that is owed by one party to another. For instance, there's trespass, there's defamation, name them. The law of property, which involves land rights, ownership, and transfer, the law of succession, which involves property, inheritance, and death, the law, of course, that governs writing a will. And so the sanctions in criminal law are in the form of remedies. For example, damages, specific performance, injunction, rescission, uh, rectification, and name them. Now, there is a difference between criminal law and civil law. In civil law, legal action is commenced by a private individual because that particular person, for instance, had a right that he was enjoying, and then that right was taken away from them, or the entity called the plaintiff. The plaintiff is a person who goes to court seeking court to rather to reinstate them or give them certain remedies against another person who has violated the right, called the defendant stroke the respondent. So suits by or against government are brought. If you're suing government, then you sue the attorney general. If you're suing a person, then that particular person becomes the defendant. Now, criminal law is enforced on behalf of the state and in the name of the state. For example, let us imagine Uganda versus Talibita, or if it is in the United Kingdom, the Queen versus John. Now, in Uganda, the constitution provides that the prosecutor should be designated as Uganda. Like I did say, for instance, in the case of Honorable Akbar Godi, it was Uganda versus Hussein Akbar Godi. So the person against whom criminal proceedings are brought is called the accused. And like I said, the accused is or stays a suspect until a competent court has found them guilty. In criminal law, the standard of proof is one beyond reasonable doubt, while in civil matters, it is on the balance of probabilities. Meaning, if you are proving your case in civil cases, all you have to, because you're the one who is alleging, then you have to prove it. And yet, in criminal cases, you must bring the accused to the scene of crime. Evidence must be laid to the extent that somebody who is before court is the only one who actually committed the crime and not any other person. There shouldn't be any shred of doubt whatsoever. Otherwise, the other person will be declared free. Now, public law. The public law deals with the relationship between the state and the individuals, or between or among states. It includes international law, administrative law, constitutional law, and criminal law. Now, criminal law is a body of rules and regulations, the structure of the principal organs of government, their relation to each other, and also forms the basis for the validity of other laws. And like I did say, that Article 2 of the Constitution defines what is a constitution. It is the supreme law of the land. Then administrative law regulates rights and duties arising from the exercise of certain powers or functions conferred on those with the sanctions, rather statutory powers, and certain individuals, because it includes local governments, institutions, and it also includes tribunals. And then private law. This is the law that governs the relationships of citizens among themselves. Private law is that part of the law which is primarily concerned with the rights and duties of persons towards persons. Now, a case in point, of course, tourism law is a private law. The business law, business transactions, sales and agency, company law. All this is private law, because that of course, it is a matter between different individuals who are governed by their contractual obligations, the terms and the conditions in their document that they have so signed. The substantive law, this is the branch of law that spells out the legal rights, duties, obligations, and liabilities of parties among themselves and government. Examples of the substantive law is the Contract and the Companies Act. Now, the Procedure Act, this is a branch of law that entails rules governing the manner in which a right is enforced under the law, or a crime is prosecuted under criminal law. For example, the law of civil procedure. There is the Civil Procedure Act, which stipulates which matter goes to which court, and it talks about jurisdiction, the scope, and of course, jurisdiction in this sense would mean the economic scope, how much money is involved, or the geographical scope, rather which court deals with what. The municipal law, this of course, by its mere name, it is the law which has its application in one state, while the international law is, like I always say, it is a matter between states or among states. And most of these laws are either, when you look at, for instance, matters at the East African Community, there is a treaty that establishes the East African Community. There is, and then of course, if I can veer off a little bit, there is also the Ramsar Convention, which governs wetlands. And so these are aspects that are among states. They are also multinational companies, or they are also international organizations, or they are also persons that are called international persons, those that are living in the diplomatic, that are in the diplomatic world. For instance, those the ambassadors, name them. Now, uh, it is important to appreciate that certain terminologies are important for you to understand. Case in point, I did say already, jurisdiction. This refers to the scope of powers that are vested in a particular court relating to what kinds of cases it can handle and is determined on the basis of the value of the subject matter or location and the nature of a particular offense. Pecuniary jurisdiction, for that matter, means the monetary value of the subject matter which a certain court is allowed to handle. For example, the Magistrates Court Act talks about certain economic, or rather certain monies that are supposed to be adjudicated or entertained by which court. There is also the criminal jurisdiction. Criminal jurisdiction extends to the power of the court to handle a particular criminal offense. Criminal offenses include what we call capital offenses, misdemeanors, and so, for example, under section 161 of the Magistrates Court, Magistrate Court is presided over by a chief magistrate and may try any offense other than the offense carrying death penalty. For example, rape, murder. A magistrate court one may try an offense other than an offense carrying. But I must also say that there is what we call courts of first instance. So magistrates court has powers to charge any other matter, and that's why they say, well, this particular matter, this particular court does not have jurisdiction for that matter. The person cannot plead, but courts of first instance are those courts where an action is originally commenced and is heard. And in that case, the court will be said to be exercising its original jurisdiction. The appellant court call it the Court of Appeal. This is the higher court in hierarchy to which an aggrieved party may seek remedy by way of challenging the decision made against him by a lower court. A case in point is imagine I contested for councillorship, and then I contested for councillorship, and then I think the results of the election are not okay with them. So I go to the magistrate's court, and then when the magistrate's court makes a decision that I am not comfortable with, then I appeal against the magistrate's court decision in perhaps the Court of Appeal. That is what will be called the appellant court. Appellant jurisdiction refers to the power of a higher court in hierarchy to either affirm or reverse a decision of a court below in a case brought to it by a party or parties that are dissatisfied with the decision of the latter court. The appellant court, after considering an appeal, may reverse the decision of the lower court on a successful appeal, in which case it is said to allow the appeal. Or it may affirm, uphold the decision of the lower court, or call it the trial court, in the event of an unsuccessful appeal, in which the case is said to be dismissed, or the court that has entertained that particular matter is dissatisfied with the evidence adduced or led. In doing so, it is exercising its power jurisdiction as an appellant court. Distinguishing cases. When court's attention is drawn to a previous case with almost similar facts, it seeks out material differences in the fact, reasoning, or approach and will not follow that case. Overruling occurs when a higher court decides a similar case on the basis of a different legal principle. The previous rule of a lower court is said to be overruled, ceased to have legal effect. Now, what we say law applicable refers to the relevant act of parliament, delegated legislation, case law, common law, equity, custom, or authoritative textbooks to be relied upon in resolving disputes. And these, in one or the other, could explain what we call sources of law. Decision of the court. This refers to the conclusion that the court draws from the summing up of the facts, evidence, and the law. For example, a judge may say, on the basis of the law and evidence as analyzed above, I find that the plaintiff has proved negligence and the defendant is thus liable in criminal case, rather in civil cases, or that the accused is guilty in criminal matters. Then there is what we call ratio decidendi or ratio decidendi. This refers to the reasoning of the court, the jurisdiction for reaching a particular conclusion, rather the justification for reaching a particular conclusion. It is also referred to as the statement or principle of law. For instance, in the case of Donahue versus Stevenson, Lord Atkins stated the famous my neighbor principle thus: every person who stands in a direct relationship with another in such a way that his action or omissions are foreseeably likely to cause injury to that other or a neighbor owes a duty of care to that person and will be held liable if such acts or omissions are the proximate cause of the other's injury. A suit. A suit means a claim that has been duly filed in court. The process of filing is commonly referred to as suing or commencing proceedings. Different claims may be instituted through various procedures. Now, it is also important to talk about the hierarchy of the court system. For instance, Uganda's court system, at the topmost is the most, rather the Supreme Court, and at the least is the LOC, the local council courts. Now, the civil stroke criminal justice system is structured in form of a hierarchy of courts with specific jurisdiction, stroke power, or limits to handle specific cases. Under Article 129 of the Constitution, it is provided that judicial power shall be exercised by the courts of judicature, the judicature. I repeat, under Article 129 of the 1995 Constitution as amended, it is provided that judicial power shall be exercised by the courts of judicature, which shall consist of the Supreme Court, Court of Appeal, the High Court, and such subordinate courts as Parliament may by law establish. Article 128 provides that in the exercise of judicial power, the court shall be independent and shall not be subject to control or direction of any person or authority. Now, the Supreme Court is the highest court, the highest appellate court under Article 132, Clause 1 of the Constitution. It has original jurisdiction in matters of the presidential election petitions. An appeal can lie to the Supreme Court from the decisions of the Court of Appeal as may be prescribed by law. The Supreme Court consists of the Chief Justice and other justices of the Supreme Court. The Chief Justice is the head of the judiciary and is responsible for the administration and supervision of all courts in Uganda, as said by Article 133, Clause 1, Paragraph A. The Court of Appeal is that second court from the highest, going down. The Court of Appeal consists of the Deputy Chief Justice and other justices of appeal, as stipulated in Article 134. An appeal can lie to the Court of Appeal from the decisions of the High Court as may be prescribed by the law. It can also sit as a constitutional court when it is dealing with matters regarding the interpretation of the Constitution, as provided in Article 137, Clause 1. The court is headed by the Deputy Chief Justice, whose role is to assist the Chief Justice in its administration. The High Court is the third court, the third court from the most supreme. The High Court is established under Article 138 of the Constitution. Subject to the provisions of the Constitution, the High Court has unlimited original jurisdiction in all matters, and such appellate jurisdictions and other jurisdictions as may be conferred on it by the Constitutional Act, rather the Constitution as provided in Article 139, Clause 1. The decisions of the courts from lower than the High Court are appealable to the High Court as provided by the law. The High Court is headed by the principal judge as stipulated in Article 141, Clause 1, Paragraph A. The principal judge assists the Deputy Chief Justice in the administration of the High Court and the subordinate courts. The High Court has various divisions ranging from the War Crimes Court, the Commercial Court, Criminal Court, Family Court, Land and Anti-Corruption, and in execution of divisions, each has a registrar and a registry. The High Court holds sessions in various parts of the country, which are called the High Court circuits for the trial of criminal and civil cases. Currently, sessions are held in Nakawa, Masaka, Mbarara, Gulu, Jinja, Mbale, Fort Portal, Masindi, and many others. Now, this, after the High Court going downwards, is followed with the Magistrates Court. These are established under the Magistrates Court Act. The High Court is empowered by the Judicature Act to supervise them. They consist of grades ranging from the Chief Magistrate and grade 1 and grade 2, while the grade 3 was phased out. A chief magistrate is empowered to supervise all magistrates' courts within the area of his or her jurisdiction, called the magistral area. The power and the jurisdiction of a particular magistrate are determined by the grade of his or her appointment and the powers and jurisdiction conferred upon that grade by the Magistrates Court Act. Specifically, Section 4, subsection 3, an appeal lies to the High Court from the Chief Magistrate or the Magistrate Grade 1. Now, the Grade 2 deals with the Family and Children's Court. Section 13 of the Children's Act provides that there shall be a Family and Children's Court in every district, which shall be presided over by a Magistrate Grade 1 and 2. The jurisdiction of the court extends to power to hear and determine applications relating to child care and protection. For example, these include custody, maintenance, parentage, as well as criminal charges against a child, except any offense punishable by death or any offense for which a child is jointly charged with a person over the years of age, around 18 years of age. It must be noted that the Children's Act provides that unless otherwise provided, matters of a civil nature concerning children are dealt with the village local council courts, where the children or a child resides or where the root of the complaint arises. Now they also, at the bottom of the judicial hierarchy, are the local council courts. These are established under Section 3 of the Local Council Courts Act 2003 for the administration of justice at every village, parish, town, division, and sub-county. They are supervised by the High Court, although the Chief Magistrate may exercise this function on its behalf. The territorial jurisdiction of local council courts extends only to matters arising in the territory of the council where the court is established, or to matters arising elsewhere if the defendant or accused ordinarily resides in that territory, the territorial area, except where the law provides otherwise. The language of that local council court is the language widely spoken in the area of jurisdiction of that very court. In other words, it is the local language. The local council courts can give remedies including compensation, restitution, attachment, and sale. Appeals lie from village local council courts to parish local council courts, from parish local council court to town, division or sub-county, from town, division or sub-county to the Chief Magistrate's Court, from Chief Magistrate's Court to High Court, with leave of, or rather permission of the Chief Magistrate's Court or the High Court. Then also there are what we call the military courts, or commonly called the General Court Martials or the Martial Courts. These are established under the UPDF Act to try all persons subject to military law. For example, every officer and military of the reserve force, when he is in uniform or on duty or an active in active service, present at any training of a unit of defense forces, among others. They include the division court-martial, the unit disciplinary committee, the general court-martial, the court-martial appeal court, and the field court-martial. In this explanation, I wanted to talk about the definition of the law. I have talked about the different courts. I have also talked about the different classifications of the law in Uganda. I remind Talibita Moses, and this information is good for students of the School of Sciences. I say all this for God and my country. I owe you, for Nkumba.